sometimes it's actually the less hyped hearings that do throw up the most interesting moments. Lainey Wilson, Adam Schiff and Ted Lowe were taking part in today's hearing into AI and identity. No doubt you've heard an awful lot about AI. It was interesting just hearing how the politicians and artists see it going forward. And by the way, in case you're wondering, is this a real Tony or is this AI? It's me, I think.
Because it's slightly outside this hearing, but it's important, I think, to get in the record. Ms. Wilson, currently the Copyright Office has said that AI per se is not copyrightable, that pure AI isn't. If today you lost that distinctive voice and yet you wanted to remix or create new works, but you wanted your voice to be heard, AI would allow you to sing though your voice be lost. Do you believe that Congress should look at the ability to copyright a work which is original but uses AI? And I say that not just for you, but for all those who, quite frankly, had a voice when they were young, and over the years, their range dissipated, and they would still like to produce the quality that made them famous.
Man.
I don't ask easy questions. I'm not paid for that. No, you don't.
But all I can do is speak from the heart, and that's really it. Because, like I said, when it comes to all this other stuff, I'm not an expert in it. But I do know that I've worked my entire life for this. I wrote my first song at 9 years old. I started playing guitar at 11. I moved to Nashville when I was 19. I've been there 13 years trying to do this. I take a lot of pride in my work ethic, and I have spent years and years and years in blood, sweat, and tears on to be where I am today. And just having that thought in the back of my head of, like, at any point in time, people could put words into my mouth, or people could take things away from me. And I've worked really hard on building this reputation. And in a split second, it could be gone. And I'm just, I want to just see a change, because there's been so many things, even in the past few months, that I've seen online from me selling weight loss gummies. And, you know, I'm a big fan of, you know, I've got a lot of little kids watching me, a lot of little girls and a lot of little boys, and I want to encourage them to feel comfortable in their own skin and love themselves. And I would never in a million years ever do anything like that. But at the end of the day, you know, people say, like, I got to see it to believe it. Well, they're seeing it and they're believing it, and folks that I'm super close to even believe it at times too. And it's really, really scary when it gets to that point.
We look forward to finding a way to protect that. Professor, just briefly, because my time has expired, the answer to that question: currently, you can't. Is there a pathway that you see that we should produce to facilitate the ability of someone to augment their own voice, the living artist, or to use their own record of voice and use AI and still enjoy a copyright capability?
I think that it's difficult.
Turn your thing on.
It's difficult in a global sense.
Mr. Ing. We now recognize the gentleman from Florida, number 1, Mr. Gaetz.
Mr. Moore, does your Association of Technology Companies endorse the No AI Fraud Act?
We have no position on it. I don't know that I wouldn't characterize us as exclusively an association of technology companies.
Is your group supportive or not supportive of the No Fakes Act?
We have no position on it.
Do you intend to take a position on either of those bills?
We're examining it.
So there seem to be two key features of the No AI Fraud Act. One is the transferability, which we've been discussing. The other is the liability. So these technology platforms that share deep fakes, Mr. Mason, do you think they should be liable for the harm that causes the creator?
Definitely a complicated question. I think the liability lies across many layers. To me, it's people who utilize the technology inappropriately, it's people who distribute it, and it is also people who host it.
Well, right now, they have no liability for that.
understand
And
that.
you've endorsed the bill that would impose that liability. So you support that, right?
Yes.
And Mr. Moore, your association, how do you think about liability for the entities that do the harms Mr. Mason described?
I think there's at least two issues in there. One is the liability of the person who creates it. The offending
Mine's
work in the
about the
first
publication. My question directly relates to the provisions of the bill that create liability if you disseminate and produce and publish these deep fakes.
So the problem that I think we would be looking at as we examine this is that when regulating in this space, it's very important to focus on the particular harm that Congress is looking to prevent. When we talk about rights of identity, there are, in general, what it does is it lumps together a bunch of different harms. There is the commercial
Mr. Moore,
harm.
I have very limited time. The
Okay.
question is, if someone disseminates deep fakes on their technology platform, is it your view that they should be liable or that they should not be liable for that?
I think the answer, for now, our position is the current law is adequate to address.
So the current law doesn't create that liability, Ms. Wilson. And so I hear about your concerns, and if these technology companies that disseminate this stuff do it, they believe the current law should exist and there should be no enhanced liability. I look at what happened to Taylor Swift. She is the most famous person in the world. And so to me, it seems as though she's just the first wave in the set. And that coming is a regime in which any prominent person could be subject to these deep fakes. And technology platforms can then generate revenue off of it and then don't want to be liable for that. Does that strike you as fair?
Absolutely not.
And why?
My heart is like beating out of my chest right now, even just thinking about it. And just like I said earlier, my reputation is everything to me. And
well, what about speech, right? Because I just heard Mr. Moore in his testimony say that actually when these technologies do like what we saw with Johnny Cash and Barbie Girl, or perhaps even with Taylor Swift and the deepfake explicit videos, that could be First Amendment protected speech.
yeah.
Do you think that your representatives in Congress ought to repose First Amendment speech rights on robots creating deep fakes and explicit videos?
It's absolutely not.
Robots should not be subject to free speech. I can't even believe I have to say that out loud. Mr. Mason, we've also talked about this transferability concept, and I want to push back a little bit at what I thought I heard Professor Rothman say. Like, why shouldn't a prominent person or any person have the right to sell their name, image, likeness? Like if tomorrow, I'm a prominent person, if tomorrow I wanted to sell my voice to a robot and let that robot say whatever in the world it wanted to say, and I wanted to take the money from that sale and go buy a sailboat and never turn on the internet again, why should I not have the right to do that?
I believe you should.
Right, and that's the bill you've supported creates this concept of ownership over your name, your image, your likeness, your voice. And maybe I'm just a country lawyer from North Florida, but the only way you own something is if you have the ability to enjoy the exclusive use of it and if you have the right to sell it. So if you can't sell your own voice, do you even really own it? And if you can't control the exclusive use of it, I don't know if you really own it. So I think this legislation is a good first step, and I think that the industry associations opposing it want to be able to avoid the liability, to be able to use the tech, and to be able to undermine the creative infrastructure that has allowed our country to flourish. I yield back.
There wasn't a question at the end, was there?
No. I asked my questions. I got the true answer.
You got a good answer. Mr. Liu.
Thank you, Chairman Issa and Ranking Member Johnson, for holding this field hearing, and thank you to the panelists who are here today, Ms. Wilson, Mr. Mason, Mr. Moore, and Ms. Rothman, for your testimony. As a recovering computer science major, I believe AI has benefited society and will continue to benefit society. It can also be misused and cause harm, and I think what we're trying to figure out is how do we allow AI to innovate but to mitigate their harms. And Mr. Mason, I'm going to ask you some questions because I want to know what the Recording Academy's position is on some of these issues. As you know, these large language generative AI models train themselves by scraping the entire internet to get data. Some of that includes copyrighted works of artists, such as, for example, Taylor Swift. Do you believe artists such as Taylor Swift should be compensated by these software companies when they use her material to train themselves?
Yes, we believe that people that have spent their whole lives, like Lainey, to create art that is being used and monetized should be compensated when it is being used. Yes.
Let's say a person who is a fan of Taylor Swift uses one of these models and generates lyrics in the style of Taylor Swift for his or her own personal enjoyment. Do you think that person has to pay anything to Taylor Swift? And do you think the software that generated that has to pay anything to Taylor Swift?
I think it would come down to use, what they used it for their personal enjoyment. Might be something to discuss, but as soon as they start monetizing that or trying to commercialize it, that's a different question, and they should be paid.
And I gather it's the same answer if the person was able to use a AI app that takes the lyrics in the style of Taylor Swift and then matches it up to a video that looks like Taylor Swift and audio that sounds like her. Same answer, right? It depends on what they use that for. If it's for their own personal enjoyment, maybe it's fair use, but if they try to sell it, it wouldn't be, right?
Yes, sir.
Okay, so Mr. Moore, I'm going to ask you sort of the same questions. Do you believe AI models that scrape copyrighted material to train themselves need to pay the people who own this copyrighted material?
Our position is that those are going to be fact-dependent. Oops, sorry. Our position is that those are fact-dependent inquiries that are going to be handled by fair use law. We don't take a position on either side.
If a person uses one of these software tools to generate content for their own enjoyment, do you have a position on whether that software tool or that person needs to pay anything to the copyright holder?
So, in dividing that, that's two separate. Those are two very different questions. One question involves the use of the tool itself and the output, right? And so, in that particular instance, that is another. I think that's another issue that's going to be litigated, because in that context, it's a lot like a Betamax. In other words, this is a technology that is capable of a lot of non-infringing uses. And so I'm not sure that liability would attach to the model itself. Again, that's something the courts are going to have to work out. With respect to the output, the question there becomes whether or not the output is substantially similar. And at that point, once the user makes that product more widely available, there would be exposure. There's potential exposure to copyright liability as well as to Lanham Act liability, for example, if they were passing it off as an original work.
Okay. What if the software company marketed their software as saying, "Hey, use us, and we can generate for you lyrics in the style of Taylor Swift and make audio and video in the style of Taylor Swift"? You think they would be liable if they did that?
Under existing law right now?
Yes.
I think you would have questions about endorsement. Styles are generally not, they're not protected by copyright. So there wouldn't be copyright liability for that. There could be, again, false endorsement liability.
And your association basically right now is just waiting for the courts to decide these issues. You don't really have a position on a number of those.
On the copyright issues, that's correct. We do not have a position.
Okay, thank you. And Ms. Rothman, I'm just trying to understand your testimony, and you can answer. I'm going to have my time end. Are you saying that a artist can't contract to sell, for example, their ability to have a recording that's going to be used in a, let's say, a future movie, a song in a future movie? I'm just trying to understand what it means that you can't transfer this right. Maybe I'm not understanding what you're saying.
Yeah, that example is a license. So you're giving permission, you're authorizing the use in a specific context. That's in keeping with all of addressing all the concerns that are raised here. The person has approved a specific use, they've given permission, then the movie studio or the record label who has permission for that recording would be able to enforce any uses if someone, an unauthorized person, subsequently used that recording or capturing of the voice, even if it was manipulated by AI in the context of the sound recording or the movie. So that is completely legitimate, would allow someone to get income, but it wouldn't take away from that person those rights. And I don't think people are aware of how many contracts they sign actually give rights to their voice and likeness and name to others. And it's a big difference whether the federal government passes a law that enables that versus some state suggesting you can do that and then someone coming in and saying actually that violates the U.S. Constitution.
I got it. So you're supporting licensing versus transferring the right itself.
As long as the licensing is limited enough that it doesn't essentially become a transfer. So it needs to be specific enough so that the authorizing party, the identity holder, knows what they've agreed to, and the public can rely on that person's endorsement of the performance that they're going to see.
Thank you.
Thank you. We now go to the gentleman from Wisconsin, Mr. Fitzgerald.
Thank you all for being here today. Mr. Rothman, you discussed in earlier hearings the need to balance publicity laws with federal law in October of 2023. Those were comments about the Copyright Office. Can you kind of expand on those comments? This is not the first time that technology has clashed with artistry, with creativeness. We heard a lot about it in Nashville last summer when we were there. The quote-unquote style of an artist has a lot to do with it. Can you comment on that?
Yeah, so I didn't testify in the hearing then, but you're right. I submitted comments to the Copyright Office when they requested some guidance on right of publicity, identity rights, and copyright law. So there are a few different issues. So one, as you mentioned, a style that's come up here before, and we tend to say people can sing in a style like someone else, and you might hear a new vocalist and think, oh wow, that reminds me of this other person's voice. We allow that if they're paying homage. People, the Copyright Act allows cover songs to be made or sound-alike recordings. It's expressly allowed under the federal copyright law. So when people sue under state publicity laws, then sometimes there's a defense called a copyright preemption defense, which says actually federal law takes precedence here, and the Copyright Act expressly allows these copyrighted uses. There's mixed answers to that. Sometimes it preempts if it conflicts with express parts of copyright law. Sometimes it doesn't. And often state publicity laws will survive a defense that someone's using authorized copyrighted works when the person's name, likeness, voice, performance is reused in a different context, say in a commercial or marketing or in an action figure, maybe that a studio didn't get permission for, or in one instance, robots in a bar. And so in those instances, courts have been rejecting copyright, what's called a copyright preemption defense, and saying state publicity laws protect us in spite of federal copyright law. In other instances, copyright law will allow such uses. So there have been some instances that the record labels have litigated, for example, where a recording artist will record a song, and then someone will want to sample it in future work. Sometimes that's licensed, and some recording artists have sued and said, hey, I didn't agree to this use of my song in this new song, and the record labels have said, actually, we have the copyright and we authorized it, and courts have generally held that in those instances, copyright law, federal copyright law, preempts a state publicity claim because it's just a record label that owns a copyright reusing the copyrighted work.
Very good. Thank you. So, like I said, it's not the first time these technology has clashed. Cher had a huge hit in the 90s with auto-tune. Hank Williams and Hank Williams Jr. collaborated, even though Hank Williams Jr. had passed away many years ago, to sing a duet. And, the latest example, I think, is the Beatles' final release here as they use technology. So, Miss Wilson, I was going to ask you, can I call you Lainey? Miss Wilson sounds weird when we call you.
Call me Lainey.
Yeah. So, Lainey, have you been in a situation where you're recording either with your solo stuff or with other artists. And have you experienced this in the recording studio where they've used these technologies, or when they play back your own songs to you? Is there a way that they enhance or can work with you on those things?
I have actually been in a couple writing sessions where people are like, hey, check this out. And they show me exactly like what they could do to pitch me a song that sounds just like me.
It sounds like you. Yeah.
And
yeah.
it's just wild. So yeah, I've definitely seen it firsthand like that. But also even just with ads that I've seen on Facebook and everywhere else, it is literally my voice.
Right.
Selling pots and pans and weight loss gummies. And yeah, like I said earlier, it's really scary when like the people that are really close to you, even some of your family members, believe it.
Yeah. Have you ever used auto-tune in a recording session with your
I have
own
used
voice?
auto-tune.
She doesn't need auto-tune.
I don't need
Come
much
on.
of it.
She's never.
It depends on what day it is. It depends on what day, you know, whether I need it or not. Yeah.
Stop talking or you need an attorney, I'm sure. Thank you very much. I yield back.
Gentleman yields back. We now go to yet another gentleman from California and a classmate of mine from long ago, and someone who's been working on transparency in this area, Mr. Schiff.
Thank you, Mr. Chairman, and thank you for holding this hearing. Thank you all for coming. I have the good fortune to represent Hollywood, Burbank, and surrounding communities, and a tremendous number of people in the creative industries. And I always tell my colleagues in Congress it's good for us to spend some time with celebrities because we get an understanding of what celebrity is, and it's not us. When people are trampling you to get the autograph of some actor in a B-level movie or a TV commercial, you get a sense of where you are in the pecking order. But one thing we do share in common with artists is none of us want to see our voice, our likeness used in a deceptive way. None of us want to see that being used to say things we never said, take positions we never held. Frankly, it's terrifying because like you in the creative industries, our reputation really matters. And so, Ms. Wilson or Lainey, I wanted to ask you, what's it like to hear some purported recording of yourself that you never made? What would it be like for an artist to hear a song they didn't write with a message they don't support, with a quality that is not up to their own standard, after you spent your whole life trying to create your brand?
I mean, it's detrimental. It's really, really difficult. You know, I try to make sure that everything I say on stage, every interview that I have, is thought out. You know, I know that it's going to stay around forever. I know people can pull it back up. And, I mean, there's been times where I have heard something and it sounded so much like me, I was like, did I say that? And it's just really, really scary to think that we're in a time that these kind of things can happen. And I just think there needs to be something done about it.
Well, let me ask our other witnesses that exact point. What should be done about it? Mr. Moore, the companies you represent, some of them are the behemoths in the technology industry. They have a role and a responsibility to take down content that is inauthentic, take down deep fakes. What are your companies doing to make sure that artists don't go through what Ms. Wilson earlier described as the gut punch of seeing their likeness, their voice, their image used in deceptive ways? And I'd like to ask Mr. Mason and Ms. Rothman if they could comment also on both what Mr. Moore says they're doing, but also what you think they should be doing that they're not.
So I think certainly with respect to copyright infringement, for example, many of our platform members have robust schemes to take down material that is infringes on those works, and they use Technological means, which I'm sure many of my co-panelists are familiar with, to take them down. That's one part. Another thing they do is they have terms of service against particular kinds of content that they do try to enforce and to get those things down. As you know, and as you've probably seen, the practice of content moderation is a really complicated one and raises a bunch of issues. The Supreme Court is considering those now, and it considered them last year in the application of Section 230 in a bunch of different cases.
Well, Mr. Moore, let me turn to Mr. Mason on that point, the takedown. What is the experience of your members when they see their voice, their likeness being misused? Does the takedown system work? Do they actually take it down? How quickly do they take it down? How many million views, listens do they get before they're taken down? Is the system working? Is it broken?
In certain occasions it does work. It is very difficult. And a lot of people, I've heard it referred to as a game of whack-a-mole. You take something down here, it pops up over there, you try and take that down. It takes too long, it's too difficult. It's cumbersome for independent artists who don't have the support of major labels, and sometimes they don't have the infrastructure or the staffing that it takes to do all those takedowns. And even some of the larger labels are struggling to chase their own copyright protection.
And if I could ask you, Ms. Rothman, if the companies claim, the platformers claim they don't have the technological means to take them down quicker, is that true? Or is this sort of a willful design not to develop the technologies that really could address this?
Pennsylvania for
I
her
think
5 minutes.
one of the
Well, thank you, Mr. Chairman, and I thank the ranking member and you both for convening this field hearing in this terrific, exciting, creative space. I'm Madeline Dean, and I'm happy to be one of the co-authors of the No AI Fakes, which I introduced alongside Ms. Salazar, who could not be here today. I want to tell you that I come at it from a number of perspectives, sure, as a legislator, but as a mom, as a grandmom, concerned with protecting children, concerned with protecting women from the abuses of deepfakes, children from the abuses of deepfakes. I also come at it as an author myself. One of my sons and I published a book telling a story about him, and my eldest son is a screenwriter and published author as well. So I'm looking at it, how do we balance the creative, the protections for creativity and one's likeness, to give a property right for voice and likeness, protect that, but also make sure that we also balance the equities and do it ethically. I was thinking and taking a look at some of the growing pains that we're going through. Unchecked photorealistic deepfakes risk public deception, as we've talked about, eroding people's faith in real evidence, facts, and reporting, critically important in this day and age. The very graphic and sexually exploitive deepfakes encompassing everything from revenge porn to child pornography, and we know that great percentage of these deepfakes tap into that gross and dark vein. And most pertinent today may be the possible inability of human creators to make a living. And to your point, Ms. Wilson, about you've honed your craft, you've spent a lot of time, you are deeply invested in it. And what you love about it is the ability to tell a story that says something about you, that reveals your humanity. And that's why we have to protect against AI-generated composition that steals our humanity. That's something I care an awful lot about. We were talking about the Taylor Swift. From the reading I saw, just one of these images was viewed 47 million times before it was removed. We can't even quantify the harm that something like that has. When we introduced this bill, it was not an attempt in any way to chill parody or satire. I love parody and satire. That is creation. That is revealing of our humanity. But I don't want lawmakers to turn a blind eye, to say that this is just too complicated and we're worried about transferability, we're worried about other things. I want to have conversations at how do we protect First Amendment rights, how do we protect artists, and how do we protect the public, frankly. Ms. Wilson, you were talking with Mr. Schiff about when you suffered deepfakes. When did you first learn of it? What did it feel like? And I'm very touched by your point that even those who know you best were confused.
Yes. It was this past summer. I think I might have been scrolling on Facebook, catching up with my folks back at home, and I see this ad. Said I had lost 70 pounds from these weight loss gummies. And first of all, it really hurt my feelings, if I'm being completely honest, because I did lose a little bit of weight, and it's probably because I played 180-something shows last year, you know? It had nothing to do with the gummies.
Not something you would recommend as a weight loss program.
But I kept having, like, people send it to me, and they're like, hey, you got to figure out how to get this down. I don't know what this is. And we would get it down, and then another one would pop up, and then we'd get it down. And it was just like we just could not keep up with it to the point to where I finally just kind of had to swallow that pill. And that's a terrible feeling, because I could not control. I wanted to tell these little kids, you know, like, hey, this is not real. I mean, I was having to tell people even in my crew. They were like, hey, I want to lose a little bit of weight. You know, tell me about this gummy stuff.
Oh, no.
I'm like...
I used to teach writing at a university, and the origin of the word plagiariste in French is kidnapper. So in some ways, some part of you was kidnapped.
Absolutely.
Mr. Mason, what are your hopes for the future of generative AI? What are your fears?
My hopes are that we can use it as a tool to amplify human creativity. My hopes around AI is that we can find some guidelines around it to allow creators who are always early adopters of technology to use it to benefit them and to bring more great creativity, more works of art to the fans and to the world. My fear is that it gets away from us and we don't have any guide rails, and that we're relying on sometimes hundreds of year old laws to protect us. Sometimes we're relying on laws that are in certain states but not holistic in a way that could protect us. My fears are that artists' careers will be damaged. My fears are that consumers will be misled, and in Ms. Wilson's case, damage artists to the point where they're upset. Their brand has been affected. My fear is that we as consumers and as people who love music get further away from the shared human experience that happens when we listen to music and when we create music and when music pulls us together.
Well, I share all of that, and I think the panel does. We are interested in finding out the right path forward. What are the right guardrails that protect the balance of interests? I yield back, but before I do that, Mr. Chairman, I seek unanimous consent to introduce for the record 2 articles. One is Taylor Swift and No AI Fraud Act, how Congress plans to fight back against AI deepfakes.
Without objection, so ordered.
And the second, just coming out today, I believe, Nicki Minaj, Cardi B, and more support No AI fraud bill in Congress, published on Billboard. And to your very point, in the image you used of a Johnny Cash fake, this lists more than 300 artists, including the estate of Johnny Cash and others, who support the bill.
Without objection, so ordered. Even though this is the Judiciary Committee, this will be heard and seen and talked about by all these members with other committees. So I might note that the Federal Trade Commission is supposed to protect many of these things and other agencies. And so even though we're looking at new legislation, we also are here to hear you out so that, in fact, we can begin pushing on the executive branch to assert powers they have, which, for example, somebody selling gummies and implying that. The fact is it's a deceptive practice, and hopefully in the days and weeks to come, we will see enforcement that might save you the I'm tired of whack-a-mole, even though it was important for you to do. With that, we go to the gentleman from Texas, Mr. Moran.
Thank you, Mr. Rice. Ms. Wilson, I see you have your hand up, so I'm just going to ask you why you have your hand up.
Because they tapped me on the back and they said it's time for me to go to Music Care's rehearsal right across the street. And I just want to say thank y'all so much for y'all's time, and this is awesome to be a part of. Thank you so much. I'm going to go to rehearsal.
Thank you.
Thank you.
Thank you, Mr. Chairman, and thank you to each one of the witnesses for your time and your testimony here today. I know it's very valuable. Proudly, I am one of the 5 original sponsors of the No AI Fraud Act, along with Ms. Dean. And I'm hopeful that exposure from this hearing in particular will help move this bill through committee. But I also recognize that these kind of hearings are very important to hear constructive feedback, to hear criticisms, to hear pushback, because we should never enter into new federal legislation lightly. In my opinion, I think we need to take it in a prudent fashion, and we need to consider all of the voices that are here today, and we need to fine-tune what we're trying to propose so that ultimately, if we pass something, which I hope we do, it will be beneficial to all, and it will be the appropriate language. We don't want anything under-inclusive. We certainly don't want anything overly broad at all. So with that, I specifically want to ask Ms. Rothman a bunch of questions today, because you've provided a lot of pushback, but Ms. Rothman, a lot of it's been very thoughtful, and I appreciate that. Let me just make sure we start from the same foundation on a few things. First, do you agree that individuals should have a property right in their voice and likeness?
Well, the property, I'm supportive of it being a property right as long as it's not transferable away. And sometimes people think of property as being sort of a simplistic thing that is automatically transferable, and it need not be. And that is another reason why I gave some examples of things we don't allow you to transfer, even if we understand them to be property. So I think it's appropriate to understand people as being able to own themselves. You can style it as a property right. Some states style state publicity laws as purely personal and say it's not property. There is a conflict in the law about that terminology, which is why I paused. If you're asking my personal opinion, I'm fine with it being classified as property as long as it's not transferable away.
Right. I know transferability is your big issue, but there are differences in state law. State to state deals with this right to publicity a little bit differently. So do you agree that there's room at the federal level for us to try to bring harmony to this issue?
Yes, I do think it is an opportunity. It's a very challenging task just because of the length of time these publicity laws have existed, and to the extent that they originated right in the late 1800s, early 1900s as part of the right of privacy that became the privacy rights that we more broadly understand, including constitutional privacy rights. Those are actually the same across all the states.
And I'm going to have to just stop you because I got a lot to ask. So hold on. You mentioned in your testimony, your written testimony, you said absent jurisdictional hurdles, Tom Hanks, Drake, The Weeknd each have straightforward lawsuits under state rights of publicity. So give us examples of those jurisdictional hurdles that you're referring to there.
Oh, so in the footnote in my written statement, I go into it. The only major jurisdictional hurdle is my understanding that Drake is Canadian, and so some state laws limit rights to those who are domiciled in the state, and since he's not a member of any state,
right? So we have some international issues. We have jurisdictional issues. We have state-to-state differences on how it's going to be enforced. In certain circumstances, an artist would have to go state by state by state effectively to enforce their rights. Isn't that true?
So Drake would likely have a federal claim already for trademark violation and unfair competition, plus, as Chairman Issa mentioned, the FTC.
In other instances, they would have to go state by state by state, and they would have different remedies. They'd have to go to different courts. They'd have different venues that they would have to pursue to have their rights protected, correct?
I don't think that's true. That's not how litigation currently works. Even Ms. Wilson departed, but she may need new legal counsel. There's a lot of lawsuits she could be bringing and that she would be winning, right? We read all the time about celebrities whose images and names are used for false endorsement. We could go back again to the early 1900s. These are winning cases. People win them. They can publicize that they win them, and they're big penalties. And you can, if you win in California, you get your damages. You don't have to then litigate in all the other states.
Yeah, but you also mentioned in your written testimony that the case law does not provide a stable or predictable roadmap for Congress to employ at the federal level if it's not a stable or predictable roadmap for us at this point, state by state, then we need to create some kind of federal roadmap, in my opinion, to protect folks. Do you agree with the concept that artists have the right to all three, credit, consent, and compensation when their voice and their likeness is used in for commercial purposes or otherwise?
Yeah, so the quote, I think, was taken with regard to copyright preemption specifically rather than the prima facie laws. But I think you said that very quickly about credit, compensation, and consent before someone's name, voice, and likeness or performances are used. Absolutely, people should be consenting for those. Whether they want compensation or not may depend on context. And credit, as people in this room probably know, is something that is sometimes negotiated with a lot of vigor, particularly in movie and TV credits.
I know I'm out of time. Some of my time, by the way, was taken for the exit, but I will say that I have not mentioned Travis Kelce's girlfriend once during this testimony. But I want to encourage this. I want to encourage the continued dialogue, and if there are additional things that we need to look at to sharpen up the No AI Frauds Act, happy to do that. But I think it's incredibly important for us to protect human creativity, both for the individual and moving forward. I do agree with Mr. Gaetz and a number of the other people on the panel that have said, look, there is a liberty in the right to contract out that, and if we need to somehow make sure that protects their personhood going forward, we can find a way to shape that. But we certainly have the right to say, hey, it's my name and likeness. Why can't I contract out or assign out the rights to that so that I can make money now or my family can make money in the future? Would like to work with you on that. Would yield back my time. Thank you.
What time? We now go to the gentlelady from Missouri, Ms. Bush.
Thank you, Mr. Chairman, and thank you, Ranking Member, for holding this hearing. And thank you to all of our witnesses for being here today. I always start my hearings by saying St. Louis and I say that because I'm all about representation. And I stand here in solidarity with all the artists, the creators, the actors whose rights and livelihoods are at risk because of artificial intelligence and generative AI in particular. Shout out to all the St. Louis musicians and artists and their fans, I got to say that. Like any technology, generative AI is not only good and it's not only bad, as we've heard here today, but its effects on our society depend on how technology is developed, how it's used, and how it's regulated. Many artists use it as part of their creative process, as we know, from the post-recording production and mastering of audio tracks to special effects in movies to the creation of visual content and so much more. But we've also seen the horrific stories, which we've heard about and talked about much today, like the deep fake pornography. We've seen the fake endorsements of products, which we heard, and I'm sorry for what Ms. Wilson is going through. We've seen the artificially generated audio tracks, like the one that's been spoken about over and over today, like the collaboration between Drake and The Weeknd, the potential for the confusion, the manipulation, the appropriation, and exploitation is huge. And beyond that, though, I want to add something that we haven't talked about yet. We must address racial bias in AI technology. If I ask a certain generative AI technology to create a picture of a black woman, the image it creates will not look like me. The facial features and hair may be distorted. And there's a lot of other evidence of this bias. For example, Google disabled its AI program's ability to let people search for gorillas and monkeys in the Photos app because pictures of black people would come up. And these issues aren't limited to the creative industries. We see it in healthcare, we see it in employment, we see it in the criminal legal system and other areas of daily life. We also see evidence of other types of bias and discrimination, including based on sex and disability. The risk to black artists in particular must be considered in light of our country's history. During the 20th century, it's crazy to say that, but for decades, during the 20th century, black musicians who pioneered new styles of music like the blues were exploited by record companies and promoters who took advantage of intellectual property law. And when machine learning technology was developed in the 1960s, its inventors did not meaningfully account for race or sex or disability or other parts of human identity. Many of today's laws and algorithms are based on earlier versions, so when laws and technology do not treat Black and brown people as fully human, is it surprising that the end products don't either? Is it surprising that Black and brown artists face an even greater risk of their rights being violated? I know that these are issues that artists in my hometown of St. Louis and all around the country are concerned about. So as Congress considers how to regulate artificial intelligence, we must address all of these issues and protect all relevant rights. Yes, we should work together to ensure people's voice, their image, their likeness are protected. We should also work together to address the bias built into these systems. We should make sure that AI cannot be used to discriminate against people, and that companies, AI companies in particular, are required to be transparent, and that we don't simply trust companies whose primary goal is to profit. We shouldn't just trust them to self-regulate and do right by our artists, our creators, our actors, and our consumers, because consumers matter as well. So, Mr. Mason, as the Recording Academy's first Black CEO, can you share your thoughts on the importance of racial equity as a factor for Congress to consider as we debate whether to establish a federal right of publicity?
Thank you, Ms. Bush. You touched on so many really, really important points. I would just simply be repeating what you just said, but there is an inherent racial bias in AI. We know that. We've discovered that. It will affect Black and brown artists disproportionately when it comes to music and art exploitation. So I thank you for what you said. It upsets me, and it concerns us absolutely. And with that, and I hate to interrupt the flow of the session, but being that it is Grammy Week and we have 10 more events coming up in the next couple of days, I have to please respectfully excuse myself if I may. So thank
Mr. Mason, if Mr. Ivey has 1 minute or less of questions, would you allow him to ask it?
Of course.
Please.
And I'm sorry.
Gentleman's recognized. No, I understand. You've been very good to us.
Yes.
Thank you, Ms. Bush. Sorry.
And I apologize for impeding on your time, but I did have an enforceability question. Actually, a couple. So the training issue, using artists' voices in this instance to train AI to create, and the discussion has been focused on making sure that the artists whose performances have been used for the training process get compensated for that. I guess I was wondering two things. One is enforceability of that, because if you use 1,000, say, artists to train the AI model, who's supposed to be tracking to make sure, we know which of those 1,000 get compensated? And then the next level for whatever it's going to be, training data 2.0, how do you even follow it then? Because not only will it use the 1,000, it might use others. So enforceability and tracking it would be one question. And then, should whatever law we're talking about putting in place still apply at the secondary level? And that's for you and Mr. Moore, I guess, or Professor Rothman as well, if you like. But you should answer first so you can run off.
Okay, thank you. It's a very difficult question, and it's a very difficult solution. We need to figure out how we can understand what is being used to train AI. And as you said, there could be 1,000 songs, and I think it pertains more to the songs, the copyrighted songs. When you ask AI to create a song in the likeness of a certain artist, it will go back and listen to records or songs from that artist to decide how to emulate them. There's got to be a way to do it, technically speaking, and I'm sure it's scary to say, but it might even involve AI, tracking AI, and what is it using. We have to be able to understand whose music, whose works are being utilized and scraped to create new works, and those people need to be compensated.
Mr. Moore?
I would say, again with the button.
Mr. Mason, thank you so much
Thank you, Mr. Mason.
for giving us so much of your time on the most important day of the most important event for intellectual property in the nation.
Appreciate it very much. Thank you.
And thank you to the clerk for pausing the time. I appreciate that.
We're fairness, if nothing else, here.
So a few things. I mean, one is that as in my own mind anyway, this is why it's really important that these cases get thoroughly litigated. Because all of the kinds of facts that you are talking about right now are the subject of very, very aggressive discovery, would be my guess. In other words, exactly how are these machines trained? What was put into them? How were they used? How are these works used? And on the back end, what steps were taken to make sure that the works were substantially similar or not, right? So that if you ask an AI engine, hey, can you give me the the lyrics to Stairway to Heaven, it says no.
Well, as a recovering litigator, I'll say this: it could take years before all of that gets solved, and you might have, and you will have, I'm sure, conflicting decisions from different courts and jury trials. What should we be doing to try and fix it now instead of waiting for 5 or 10 years from now?
Well, right now, in terms of identity versus copyright, right? For copyright, from our point of view, is the courts are the institution that are best equipped to deal with these issues for now. With respect to the identity issues, I think...
Let me ask you then, how would the copyright law apply to the hypothetical I gave you, especially for training data 2.0? Is there applicability under current law for that?
So, oh boy. So I'm a recovering lawyer too, but it appears we're both having a relapse. Can you define for me one more time what training data 2.0, what you mean by training data 2.0?
Well, I guess there's the fair use question, right?
Right.
So you train, and I forget what he said, but let's say Motown hits. You want to generate Motown hits, so it takes 1,000, yes, I'm showing my age. You take 1,000 songs from Motown, and it trains it up, and then you can use that for the AI system to generate new material. Okay. And the argument, I think, is that that's a fair use issue, and that the performers, the original creators, should still be compensated. The question was, how do you track it? And then the second question is, even if we assume it's a fair use issue at level 1, is it still a fair use at 2.0?
So, in other words, at 2.0, you mean the output stage?
Yeah, because at the next, okay, well, no, actually, the next level, you'll train it. Mm-hmm. You'll train one system, right, and then it'll generate songs then. But then you'll have other systems that are doing the same thing, presumably. You could have another 1,000 of these new systems that then train the next level of the AI generation. That's the 2.0. So the 2.0 trained by, and I'm running out of time, but what do we do there? Under current law, because you're saying we should follow that.
That's a really good question, and I am going to take that one for the record, if you don't mind.
Mr. Chairman, I had to start right in with the questioning, but I do want to thank you and the ranking member for giving us a chance to have this hearing. The transferability issue, I'd love to chat with you about it, because I want to understand the James Earl Jones scenario, but I guess we'll have to do that offline. But thank you so much, and thank you to the witnesses. I appreciate your insight.
Thank you. As we begin to close, I'm going to take a couple of quick liberties. I'm going to ask the ranking member to make a closing statement. I'm also going to note that Congressman Schiff has been working diligently and has draft legislation on transparency of ingestion. One of the greatest questions is, Mr. Ivey, you said, well, if you went for, by the way, Motown is current. Let's not pretend it's old. Okay. At least on my albums it is. It's eternal. But if you knew you ingested it for that purpose, it would be relatively transparent to begin with. But I think Mr. Schiff is looking at something that ingests most of the internet, something that ingests vast amounts of information, and how do you, in fact, find out after the fact when, and I'll yield to the gentleman for a minute to explain what he's working on, because I think it's critical.
Thank you, Mr. Chairman. We're working on legislation that would require transparency for artists when their material is being ingested to essentially build these AI platforms and models, so that it can be tracked, so that where intellectual property is protected, they have a right and a remedy and a recourse. But I think the key is making sure that there are systems tracking what is being used to inform these AI systems, and so that artists can be compensated when their works are used this way.
I thank the gentleman, and I think Mr. Moore that